Hi, I'm David Mandell, and today we're going to be covering the subject of reducing physician stress through risk management and asset protection planning. Now, like you'd expect from any good attorney, first we're going to have a couple of disclaimers. This is not and should not be treated as legal advice. The point of today's talk is to give you a good background, bring some ideas up to awareness for you so that you can go back and see how they might apply in your personal planning. And we hope at that point you'd consult with somebody who is experienced and licensed to help you in these areas. Now, the good news is we have a long-standing relationship with the AEI, and I'm pleased to say I've been speaking here for at least 5 years. And in part of our relationship, we want to further the education that you as attendees get, not just from this lecture, but ongoing. So here you can see a number of books that I've authored or co-authored over the years that you can get for free as being an attendee at the AEI conference. Now, for some of you who are repeat attendees, you may see some of these books before, and hopefully you've gotten them before. But there are a couple of new ones that I want to point out. First of all, for the new folks, the top left, if you're a physician, the book for doctors only is kind of our flagship book. It is a nationwide. It's good for any kind of specialist, any kind of employment situation, your own practice or employed, and for any state in the country. You can also see on the top a number of books we've written for specific states. So we did those with attorneys licensed in those states: Georgia, New York, California, and Ohio. Then on the bottom row, you'll see some books for specific specialties where we did it with actually a client of ours in that specialty, dermatology and orthopedics. But the most important ones I want to point out to you are relatively either new or there's a change to them. The first one is Risk Management for the Practicing Physician. You'll see that on the bottom row. I want to point that out because it's a CME monograph. So after doing your AEI conference, if you still need credits or you know someone else who might, this is certified for 5 hours of Category 1 CME credit, and even though it's been out there for almost 20 years, since 1998, this is the first year where it's also in Kindle and iPad format. So again, as an AEI member, I'll tell you at the end how you can get these for free. The last book I want to point out is in the bottom right, and that's our Wealth Management Made Simple for Physicians, and that's a new book on investments and retirement planning, and that's completely new. I'm very proud of it. I think it's our best book yet. And again, you'll get it for free if you want by following the instructions on our last slide. So today, what topics are we going to cover in risk management and asset protection? Well, first, we're going to just briefly mention the background of physician stress and why these topics are important, because they're on the mind of many of you practicing medicine out there. Secondly, we're going to talk about the difference between risk management and asset protection, and then drill down for a number of minutes in a specific subsection of risk management. What to do about texting, and what are the risks there, and what can you do to improve that. Then we're going to get into asset protection planning. What does that mean? What's the background? What is the discipline about? And what are the sort of pros and cons to it? And then we're going to, again, drill down into a specific area of asset protection, which is planning for cash flow and personal assets, how to protect the money you're earning and your personal assets like your home and investments and what have you. So first, let's talk about physician stress for a minute and how that relates to liability. Well, in a recent survey, and I reference it here on the slide, 87% of the respondents, who were all physicians, said that they were mildly or severely stressed on a day-to-day basis. And for those physicians in the room, you can maybe be nodding your head and think, oh, that might apply to me, at least on some days. I mean, for all of us, we have stress at work on some days, so that's not surprising. But I think what's concerning about in the medical area is how pervasive it is, and there's a number of reasons for that. Obviously, the pervasiveness of regulation, and all the physicians have to deal with there, economic changes, and in past talks, and maybe in future, I've dealt with, for AEI, I've dealt with that issue, more on financial issues. Today, one of the stressors that we're really trying to address is the sort of ever-present threat of being sued. And I can tell you as someone who has over 1,000 physician clients, some at my law practice, some at my financial firm, OJM Group, and also someone whose grandfather, brother, and father or are physicians, that stress is real. And it's hard enough to do a good job for your patients and work hard for them, but then to see that they might become an adversary or that every move you make may be second-guessed and torn apart in some kind of malpractice action, that's stressful. And so today what we're trying to do is give you a couple of tools in the toolkit to start to deal with some of that stress. From a macro perspective, the threat of litigation and lawsuits is also damaging to all of us as Americans because certainly, and I refer to a particular article here, the threat of that kind of liability and lawsuit leads to quote-unquote defensive medicine. And I think all physicians can point out in certain activities they've seen from colleagues or even from themselves to say, when in doubt, cover themselves because they don't want to have liability. So there's certainly a lot of data out there on how many tests are run that may not be medically necessary just to make sure that there's not going to be any liability for missing anything. And so not only for the physician themselves, for you, the attendee, but also for the sort of the general populace, as we're all patients as well, dealing with how to reduce that stress level, things we can do in behavior-wise, and then also what we can do protection-wise, I think is good for every physician to consider, perhaps implement, and hopefully today you get a couple of good ideas to take away on that. So what kind of liability do physicians face? Well, so far we haven't said it yet, but it's sort of been in the implied, which is medical malpractice. It's probably the one that's of most concern to most doctors because you're seeing patients every day, and there are multi-million-dollar awards for pretty much every jurisdiction oftentimes during the year. So that's sort of the big one. But unfortunately, it's not the only one. I can say this as an employer myself in my firms. If you employ people, so if you're a physician who has your own practice and you have employees, then you have potential employer liability, and that could be anything from hiring and firing, wrongful termination, to discrimination, to harassment. Even if it's not on your behalf, you could have liability for a partner. You could have liability for an employee in something they do. Okay, so that's an issue that's out there. Specific to medicine, there are billing issues, and as we talk about risk management when it comes to texting, that's not medical malpractice. That's not employer liability. That's a new area of liability that's sort of come up over the last 5 to 10 years regarding HIPAA. And I've seen a number of physicians and practices get in hot water because of HIPAA violations. Again, it might not have even been from the physician. It could have been from somebody in the office. There's other areas as well, billing issues, and overbilling from private insurers or Medicare. Certainly if you have real estate, and a lot of clients of ours do, there's slip and fall and that kind of premises liability. And then there's personal liability. Probably the area I've seen physicians get in the most trouble with over the years is signing personal guarantees on outside businesses or real estate deals that come back to haunt them. And then there's personal liability from a car accident point of view. If you have teenagers and they're driving the car, that opens up a whole nother can of worms. So again, the point here isn't to overemphasize or to keep people up at night, but it is to say, let's recognize what risks are there and let's do something about them. Let's be conscious of them and perhaps perform better in what we're doing and be a little more risk management focused, which we'll talk about next. And then also recognize that no matter what we do, there's going to be risk out there. So let's spend a little bit of time and maybe a little bit of money protecting what we built so we don't have to worry about it. We're less stressed. Ideally, we become a happier and better professional, in this case, physician. So risk management and asset protection are the two topics today. What are the differences? Well, as someone who's written books on both of them, I think I can give a couple of insights. Risk management is really about behavior. It's about improving behavior so that you reduce the chance of risk. Right? That's the focus of risk management. And it was a topic when I first wrote the piece, Risk Management for the Practicing Physician, which I've actually written since 1998 with my father, who's still practicing part-time as a radiologist. But he did it because he was practicing in Massachusetts where there was a CME 1-hour requirement for risk management, but there weren't many resources out there to get that CME hour, so we created our own. And now it's done well for us for 20 years, and again, free for you, I hope you get it. But the point is, risk management now has become, I think, much more ubiquitous in that you see a lot of medical malpractice insurers having classes on it because they want their physicians to practice better because there's less likely of claim payout, right? So risk management is about improving behaviors so you reduce the likelihood of risk. Seems obvious by the name, but it's important to realize. Asset protection isn't about reducing risk at all. It's about recognizing that regardless of how well we practice, how well we drive, how well we maintain our real estate, or try to deal with our employees, there's liability out there. And so asset protection is a discipline that, and it's really multidisciplinary discipline, as you'll see, that the point of it is to structure either a business or a practice or someone's personal assets in a way that if there ever is liability, that you're well protected. Okay? So one is about behavior, reducing the risk, very wise to do it in my own businesses. But then there's also acknowledgement that regardless of how well we practice, there's human behavior, there's human error, there's other things that may happen. And so it makes sense to do some asset protection planning behind that. So let's talk about one topic, one mini topic in risk management. Certainly we could do a whole hour or maybe certainly more hours than that on risk management. And there's a lot of different topics in our CME piece. This is just one area within the chapter on new technology. Because if you think about all of new technology, and one of the other things we address, there's social media. A lot of people are concerned about, hey, what if I get a bad comment on social media as a physician or a bad review? What should I do about that? That's concerning. There's certainly websites for certain areas of medicine, especially cosmetic. There's a lot of material that our clients are putting out there on their website, and sometimes they're even answering questions and interacting with patients or potential patients on the web, and that brings up a host of issues. But today we're going to talk about texting, something we all do, and as physicians, especially when it comes to protected health information, PHI, it brings up a whole host of potential risks. 2012 study, which now is a couple years older, obviously, but I wanted to still refer to it because I bet the numbers are even higher today. 73% of physicians in the survey said that they had texted about work, maybe with other physicians, maybe with the office, etc. Now, it didn't say specifically patient information, but one can probably assume that some of those texts had to do with patients and some of their either medical conditions or what they were going to do about it or what the next step was. The risk here is not really medical malpractice from a point of view of treating the patient. It's HIPAA and the rules around HIPAA regarding protecting that protected health information, PHI. When you think about texting, there's a couple of risks that probably are obvious, but let's point them out. One is text messages can reside on the phone or the mobile device indefinitely. Thus, if you lose the device, if you sort of put it out to pasture, retire it, if it's stolen or recycled, someone could potentially get to that information, okay? So there's a big risk there. There's typically very little authentication protection on the device for text beyond maybe a password for your phone, which is not really strong. Certainly there are stronger methods. And often, especially in a larger practice or hospital environment where they have a significant IT department, those texts may not be monitored. So you've got this information out there that's not really being monitored by the IT department, and that assumes you have a large IT department. If you're a solo practice or small practice, you may outsource that, and they may not be able to monitor those either. So you've got this protected health information, which puts a real liability on the providers through HIPAA, and there's a lot of risk out there. So what can we do about it? I refer here in the slide to an article that we reference in our CME risk management monograph. I want to glean out a number of, I think, top pieces of advice for physicians when it comes to texting. Okay, One is you want to have a policy in your practice. And again, if it's a large practice, they may have one already, but for many small practices, they haven't gotten around to doing this, of what can be shared by text. And again, it's not just the physicians. It could be nurses, it could be physician extenders, it could be the front office, et cetera. You have to be very clear and have a written policy around that. Otherwise, it could be negligent by you by not having that, okay? And along with the policy, training that goes along with it. What can't be text? Maybe you have a ban on it completely. Maybe there are certain things you can text or not. And again, this is why consulting with a healthcare attorney in your area, in your jurisdiction, who is very familiar with HIPAA rules and what's changing. Because bottom line is, anything from the government, there's changes that happen over time, and you want to keep up with it. Password protection, encryption, all of these software/hardware attributes that you want in your devices are crucial for anything that's going to have protected health information. That also means an inventory, meaning understanding what devices are out there. In some practices, for example, in my business, which has really nothing to do with HIPAA, but in the financial world, we have a lot of confidentiality and private information requirements. And so that is why we actually own the phones that we provide to our key investment people, because we have the ownership of them, we have the ability to monitor them, we have the ability to track them, and if they leave the firm, we have the ability to take it back. And that might make sense for some medical practices for the key medical providers. Proper sanitation of the device. If you're going to retire it, as they say, hey, I'm getting a new phone. Well, what happens to the old phone? They shouldn't just sit in a drawer. You need to make sure that that device is not only monitored or perhaps taken back if you own it as a practice, but also sanitized so that that information is deleted. Probably the most important piece of advice is the last bullet here, which is going beyond perhaps your normal texting application to a secure messaging application. Instead of just texting on your phone using, if you're an iPhone, iMessage or what have you, but actually going out, shopping around, looking for those applications, and a number of them have come up, and I think that they're well reviewed. They have a lot of experience in the medical area now, where you can purchase that app for all the key devices, and then you're not texting on the normal sort of airwaves, as they say. You're texting through the app in a secure environment, and many of these that you'd be considering are HIPAA compliant. So if you can think about some of these behaviors, again, risk management behaviors in terms of training, in terms of what you're doing with the devices, if you can get the right third-party HIPAA compliant apps, you can still use the benefit of texting, which is very valuable. You're on the road, you're going to the hospital, you're coming to the practice, you want to be in communication. It can be very timely, very important, but you want to do it in a way that doesn't bring on a whole level of stress and another worry about liability. And these are some of the ideas to do that and to get you started on the road to incorporating texting in a HIPAA compliant way in your practice. So that's one topic in the world of risk management, what to do about texting within the subtext, the subcategory of social media and new technology and other sort of newer risks that you may not have been trained for. If you were in medical school, more than 5-7 years ago, these things probably didn't even come up. Certainly those of us who are a little bit older and went to graduate school 10, 20, 30 years ago, it certainly did not. So I encourage you to take some of these ideas, take them home, and then expand on them by working with somebody locally who is experienced who can advise you there. But as I said in the beginning, risk management in any topic, whether it's medical malpractice, whether it's taking care of your real estate, whether it's texting and new technology, can only go so far. There's going to be human error, there's going to be perhaps technology error that leads to potential liability in all the things we do. So asset protection really is there as a backstop. It's a backstop to say, we have risks, we want to reduce our stress level, what can we do to protect everything that we've already built and are ongoing to build? And that's what we're going to talk about now. Now this scale here is very important. It's important because everything I'm going to talk about after this is related to the scale, meaning when AEI attendees and viewers contact me, and I hope that you do. If there's questions you have, make sure you note them down and contact me. I always respond to those as quickly as I get them. And it's part of the interactive nature, one of the benefits of the AEI program. I'm not just here on a video, I'm here willing and able to answer some of the questions that might come up when you're watching this. But one of the questions I get from folks who haven't got the benefit of seeing a video like this is, am I protected? Is my house protected? Is my investment retirement plan protected? And that kind of black or white question, am I protected or am I not, doesn't really have a place in asset protection planning. That's why this scale is so important. Well, I've had it in the books for about 20 years. There is a relative scale of exposure on the left side at -5, all the way to the top level of truly protected at +5 on the right hand of the diagram. So when I see most clients, they're in the negative positions. They're owning a lot of their assets in their own name, or if they're thinking about their practice, the practice owns the asset. So it's exposed to any lawsuits or creditors at the practice, or if I own it in my own name, it's exposed to any lawsuits or creditors I may have, any liability, unless it's an exempt asset, which we'll talk about. So when physicians come to me, or any other client, and they're interested in this area, well, what our goal is not to get them to the top level of +5 across the board, every asset. If you think about your balance sheet like a pie chart, you can't get every piece of that pie at +5. It's just not realistic. Even I don't have that. I have a lot of my assets very well protected, but it's not +5 across the board, okay? And some of that's state dependent. I happen to reside in a terrific state for that, in Florida, but I have clients in all 50 states, so we have to deal with what we're given in the state we live because state law does have an impact. So the goal here really is to move clients, and especially their key assets, the one they worry about, the ones that may cause them stress in their practice, et cetera, the ones they're concerned about, from the negative positions to at least the positive positions. And if you look at that scale, you're going to see a lot of different types of terms, and we're going to cover them in the next couple of minutes. But one of the things I want you to take from this is they're not always legal tools. Lawyers, and I have a law practice, as well as my wealth management firm position as one of the owners and founders. And both of those firms provide value to clients in asset protection planning. So does insurance. I mean, medical malpractice insurance, homeowners insurance, an umbrella policy. These are all building blocks of a good asset protection plan, as are some of these tools you see in the middle of the scale, limited liability companies, limited partnerships, things that you go to lawyers for, okay? And everything in between. You can see at the +5 area, state and federal exemptions, which we'll talk about in a minute. Those are typical things you don't need to go to a lawyer for because you're given them by the federal or the state government in the state that you're in. So keep in mind this chart. It's really important. It's in our books as well, because you want to be thinking, what are my assets in the negative positions? How can I move them up without a lot of expense or difficulty to the positive positions? But don't think of it as black and white, protected or vulnerable. Now, one of the chapters I've had in some of the books in the past, and one of the things I've mentioned in the lectures like this, is the saying, the best asset protection is not asset protection. Well, you know, it seems like a very Zen thing to say, but there's actually some truth to it. And it gets back to the scale that I was talking about. At the top of that scale, the +5, the assets that are truly, quote unquote, protected or off the table, those are tools that many of us have, and we don't even think of them as asset protection, like your home. For example, I live in Florida. We have an unlimited, in terms of value, homestead protection. So every day I come home, I'm living in an asset protection tool, but I don't think most people who purchase homes in Florida think of it that way. Every state has some level of homestead exemption, from 0 in New Jersey to about 5 states that have an unlimited value. And most of them are in the 30 to 50, some up in the hundreds of thousands of dollars. So it can be a significant part of protection planning. So are other tools like qualified plans. Your 401k is a savings plan. It's not an asset protection plan, but in fact it is. Okay? It is at that +5 level. Now, the other thing that's also important about asset protection is there's got to be economic substance to it. There's a timing issue. You can't wait until you have a problem and then transfer assets into various tools and think it's going to protect you from that problem. Again, as someone who's been doing this for over 20 years and been out there speaking and writing about it, I've gotten my share of phone calls from physicians who say, I just had a bad case, or even worse, I've just been sued, or even worse, I'm going to court. That's too late to really be effective in the planning against any kind of liability and asset protection planning. The best planning is done when the coast is clear, when there's nobody out there that we're concerned about. We're just generally concerned that there might be liability in the future. And for any of you watching this, if that's your position now, that's when to take seriously these planning, this type of planning, and to put some of these ideas in place. Now, if there's some of you in the audience who already have something you're concerned about, that doesn't mean we're paralyzed. Okay, I have some clients, maybe not so much physicians, but some real estate developers, et cetera, who always have some lawsuit pending against them. They're just in and out of deals that sometimes go south, and so litigation isn't something that they're immune to. In fact, it sort of it goes part and parcel with their business. That doesn't mean that we can't do anything for them. It means that we can put this kind of planning in place and know it's going to be much more effective in the future. It may not be so effective about items that are on the table today, but at least it gets them a starting point to go forward. So if you're in that position watching it, again, it makes sense to examine some of these ideas. But the last bullet point here, again, I'll reiterate it because I mentioned before, is the best asset protection planning is a multidisciplinary plan. It's not something you just go to a lawyer for. It's not something you just go to an insurance person for or a financial advisor. The best planning has an element of all of those. And you can use the analogy of medicine. I mean, how good is a surgeon if he doesn't have an anesthesiologist with him? Well, the patient's probably going to run out of the room because he doesn't want to get cut. An anesthesiologist without a surgeon, obviously someone's going to go to sleep and wake up really no better than they were before. You need the coordination in that area of medicine, just like you need it in asset protection planning, very similar. So if this is something that resonates with you, make sure you're reaching out to either a firm that has that multidisciplinary approach, or you can put some of the key advisors together. Now let's go to the first topic within asset protection, which is cash flow protection. This answers sort of the common question, well, what do I do about the money I'm earning? How do I protect that? Very important, obviously. Well, the first thing we want to do, or probably the main central tool, are benefit plans at the practice. Now, this gives a distinct advantage to those of you in private practice where you have control over what kind of benefit plans you have today and what you could add on, subtract, or add in the future as taxes change and rules change. For those of you employed at large institutions like big practices or hospitals, and certainly as someone who's advised physicians for 20 years, I see a lot more of that, given the consolidation over the last 5-10 years, then at least you want to understand what plans you've got, what options you have, and what you can take advantage and what the benefits are relative to that, and how your personal planning should be adjusted based on what you've got or don't have at the practice. A lot of folks who've been in private practice, then they get acquired, they realize they've given up their non-qualified plan, or they've given up a very generous qualified plan, and now it's a much more limited 403B or 401K that they can't put as much away into. Well, are they making that up with their individual planning by doing some forced savings, non-qualified plans, some things on their own? Very important. We have helped a lot of clients do that, so they get the benefit of going into a large institution, maybe some less liability, maybe some better risk management, some less stress about some of these issues, but they are able to make up what they've given up, which is typically less tax planning, less benefit planning, et cetera. So again, I think it's important for you, whether you're employed or have your own practice, these concepts apply the same. So what's the rules here? Well, qualified retirement plans. Qualified retirement plans. These are 401ks. These are 403Bs in a hospital setting. These are pensions, defined benefit plans. These are profit sharing plans, okay? These are, especially if there's more than just a couple of employees, what are called ERISA qualified. And that is a particular legislation, the Employee Retirement Income Security Act, ERISA. Well, there's a Supreme Court case that says ERISA qualified plans are exempt in bankruptcy. So Many of you say, well, bankruptcy, what does that have to do with it? Well, that's where we get some of these asset protection rules, because ultimately, if there's a lawsuit against somebody and they want to get rid of that liability, that claim, that judgment, and keep their assets, we know that bankruptcy is sort of the backdrop. That's the rules where the sort of the rubber meets the road. On the other hand, many state, and we'll talk about in a second, state exemptions are there for qualified plans as well. So these are terrific tools. These are at the top of that scale, +5, okay, under federal law and under almost all state law. Okay, there are also other benefits, as you know, and again, this gets back into the asset protection not being asset protection. Most of you who participate in these types of plans do so because you get a tax deduction for it, because it's forced savings, because it helps you with your retirement planning. It may have some long-term tax benefits too, especially Roth IRAs and non-qualified plans. So these are tools you may be doing for a lot of other reasons, but if they're ERISA qualified, they're well protected from an asset protection point of view. Now, if you're going to use qualified plans and you have the ability to make some changes, meaning you're in a small practice or you have partners and you have some say, some control over what type of plans you have, there are a number of things to keep in mind. You want to make sure you have the right formulas, okay? There's nothing, certainly we have in our firm and certainly advising other clients, we're not here to give the employees as little as possible. On the other hand, okay, any dollar that goes in from an owner, from a physician owner point of view, has to be justified by how much you can put in for yourself. I've seen many clients who've come to me who have given up their plan, who've terminated it because it got too expensive for employees. Well, that's a lose-lose. Now the employees don't have the plan and you don't have the plan. So making sure your plan A is compliant, there's another area of risk management and potential liability if it's not, because if you have a plan that's not compliant, the Department of Labor comes in, they could fine you for that. So making sure A, it's compliant, and B, it's maximized for your benefit. These are formulas that change over time. So if you haven't reviewed your qualified plan at a practice in a number of years with a professional who knows what they're doing, we have someone in our firm who does that all day long, you should, because you might be giving up dollars, giving up tax deductions, or hopefully not, in a place where you're not even compliant and you have a potential fine sitting out there. You want to be conscious of the fees involved. This is another thing. If you haven't reviewed your plan, a lot of legacy plans, a lot of older plans that we see in medical practices are very expensive, much more than they should be. Prices have come down, okay? So you may be paying too much on the administration, you may be paying too much on the investment options. Sometimes those are bundled, so it's hard to tell what you're paying. Very unclear, and many times by looking at that we can come in and say not only can you get a better plan where you get more deductions or you have some options, but you can also reduce your fee, okay? Everybody likes that. So again, there's potential benefits if you're doing it in a way that's not maximized, but there's also risk management in that you want to make sure that plan is not subject to any kind of penalties and you're actually compliant. Now what about IRAs? A lot of people think of IRAs as retirement plans, but from a legal, technical point of view, they are not, okay? They're custodian accounts. So they're treated in many ways the same, in some ways different. From an asset protection point of view, the exemption for qualified plans that I mentioned came out of bankruptcy in a Supreme Court case, was codified in the Bankruptcy Act in 2005. So now we're 12, 13 years into it. So IRAs under bankruptcy, they have some limitations depending on, like around $1 million depending on the type, but a typical sort of rollover or a SEP IRA is unlimited in its protection, okay? Those rules do change from time to time, so again, make sure you're being advised by somebody who is professional and licensed to give you that advice locally, especially because the state laws on IRAs range. Okay, from unlimited protection, treated like a qualified plan, again, where I live in Florida, that is true, to where I used to live, and I'm still a member of the bar in California, IRAs are not given the same level of protection. It looks that way in the statute, but it says the amount reasonably necessary for support. That qualifier is not there for qualified plans, ERISA qualified plans, and so what does that mean, reasonably necessary for support? Well, that really means it's up to a judge to decide in a certain case how much is reasonably necessary for support. I don't consider that as well protected as a qualified plan that doesn't have that limitation. There are other states that put an actual dollar limitation on IRAs as well. So for many of you, you may have thought, well, I'm in my own practice, I'll just do a SEP IRA, it's cheaper, without realizing that you're making a real choice from an asset protection point of view in some states of an IRA is really not as well protected as a qualified plan, and most physicians making that choice aren't aware that they've made that asset protection decision. They think they're kind of done the same, and frankly, a lot of people who are in the financial side of the business, the people running the investments or the third-party administrator, they're not really as well advised on asset protection planning, and so the client's not getting the right advice. So if you have an IRA, it's really important to get with someone to understand how is it protected federally, how is it protected from a state point of view, because it is slightly different, and in some cases, majorly different than a qualified retirement plan. Now, what about other benefit plans? In other talks for AEI, I've drilled down in this topic, especially from a tax and financial point of view. But there are non-qualified plans. In fact, I was just at a surgery practice, orthopedic practice last week, presenting to them about a non-qualified plan. Well, what's the benefit of that is you don't have to offer it to any employees. In fact, of the 15 or 17 orthopedic surgeon partners, there's only a couple that want to do it, but that's fine because it's not a qualified plan. It's totally separate. It's taxed differently. And as I say this, depending on how tax rates go over the next 4 years in this administration, maybe beyond that, it may be the ideal time, meaning it may be the best time in 30 years to fund these types of plans, because if income tax rates go down for high taxpayers, tools like Roth IRAs that go in after tax, or tools like non-qualified plans that go in after tax, that grow tax-free and can be accessed tax-free, this may be the best time we've had in 20, 30, maybe even more years to fund these types of plans. So again, we're not going to spend a lot of time on these today, but these also have, in some states especially, that top level of asset protection, that +5 level of protection to take income off the table before it comes into your name. So again, depending on where things go, or even if the tax rates stay the same, they're very attractive. It's something I've done for myself. And if you don't have a non-qualified plan in place and you have the ability at a practice to make those decisions, this is something you should examine, not just from an asset protection point of view, but also for all the other reasons. Again, the best asset protection is an asset protection. This could be a way to protect assets, but also do some long-term tax planning, forced retirement savings. Some clients even use it to build up to pay the tax that they'll owe on their qualified plan when they pull it out in retirement. So a lot of benefits there, something worth looking into. Now let's talk about protecting the personal assets. You practice medicine, you earn money, you pay tax on it, and then you put it somewhere on your balance sheet beyond what you spend, right? That could be putting in your home. That could be a second home. That could be an investment portfolio. That could be some other investments in surgery centers or other types of assets. So let's talk about, over the next 15 minutes or so, what your options are. The first one is, how do I title it? Meaning, how do I own it? What's the legal title, the form that I use to own it? And a lot of clients will come to me, or potential clients, before they work with me and say, I just put everything in my spouse's name. Generally, and again, I'm addressing potentially clients from all 50 states here, that generally doesn't work. Now, again, it depends on the state rules specifically, but certainly in community property states, that doesn't work, because in community property states, it's not about the title. If there's an asset that's acquired in the marriage for the community, then any community debt can access that asset, meaning it's vulnerable to any community debt, which means liability against either spouse. So titling it in one spouse's name is not going to change it from community property. So in those states like California, again, one state that I lived in, and a lot of the western states that have community property, we know that's not effective. But even in the majority of states where we have what's called equitable distribution when it comes to a divorce, but from a creditor point of view, just putting assets in the spouse's name is very suspect. Why? Because what are you getting for it, right? If you're put say the home in the spouse's name, but you're still living in it, and you're still paying the mortgage on it, and your income is still at least part, and maybe all of it, paying the property taxes on it, then have you really given anything away, right? And the question I always ask clients is, if you put everything in the spouse's name, what do you think happens in divorce? In case you get divorced, hopefully it doesn't happen, but in fact, it's much more likely than losing assets in a malpractice action. And most of the time they'll say, well, of course it's in the spouse's name, but if we get divorced, I mean, really it's both of ours, wink, wink. Well, I say it's not that hard for the attorney on the other side to figure that out. Meaning it's very, I think, risky unless you have a lawyer, again, in your state who's advising you, and I recommend you get it in writing, that this can be effective from a protection point of view, but still from a marital dissolution point of view, you sort of get your cake and eat it too. You can protect it against claims against you, but if you get divorced, it's still half yours. Unless you can get that in writing from somebody locally who's experienced, an attorney, then I'd be suspect of it. And again, I don't really recommend it for almost any of my clients, and certainly not in my own circumstance. Now, for about 10 states, they have what's called tenancy by the entirety, mostly southern states. And in some of those states, both real estate and personal property, and in other states, just real estate, can be effectively protected by putting in that ownership form against a claim against one spouse. So for example, I live in Florida, we have tenancy by the entirety. Let's say I own an asset in tenancy by the entirety with my wife. Then, again, as long as there's no fraudulent transfer timing issue, any claim against me is ineffective against that tenancy by the entirety property. So I can own it jointly through that ownership form with my wife, but anybody suing me can't get to it, or anyone suing her. But there's a vulnerability if someone sues both of us, there's no protection whatsoever. So again, for some clients in the states that have that, for the right asset classes, it can be effective. I rely on it to some degree myself, okay? This is why it's so important to find out what the rules are and work with somebody who understands the rules locally. So beyond titling, which again, other than tenancy by the entirety, there isn't a lot of good options there. You want to use what you can get. And the first option, the first sort of no-brainer to me, is using with exempt assets, or starting with exempt assets and using those. Why? Well, back to the scale slide. Top of the scale. Can't do better than +5 protection because this is what a state or federal law says is off the table. This is how people can file for bankruptcy and come out and be multimillionaires. A lot of people ask me, well, how can someone be bankrupt but yet be wealthy? Well, one of the reasons is exempt assets. There are assets that even if you had to go through bankruptcy, Chapter 7, that are off the table. And so you can come out of bankruptcy and keep that asset. Now, we're just talking about a normal lawsuit situation, not bankruptcy planning, but a lot of those laws overlap. So you can get sued, and there are assets in every state that are off the table. Why not use those? You don't have to pay lawyers like me. You don't have to pay accountants to do more tax returns for different legal entities. You don't have to pay states. You don't have annual compliance fees. So why not take those sort of, they're not freebies because they're not free. No one gets a home for free. You don't invest in a 401k for free. But those are assets that you can own and control and have access to, and they're protected at the highest level. So what are those types of assets? Well, typically, again, I mentioned homestead already, okay? Most states have a homestead exemption. They're not always great, but we have to understand at least what the rules are and how much of that net worth is protected. A lot of states have protections for qualified plans and IRAs, as I mentioned. Many of you may be using those already. If not, worth looking into. Many states have protections, even unlimited protections, for asset classes like annuities and cash value life insurance. Again, I'll use myself as an example. In Florida, we have unlimited protections for both cash value life insurance and annuities, and part of those form the plan that I use, that my brother who's a cardiologist used, that my father who's a semi-retired radiologist used. We've all used some of those asset classes because they fit our financial plan, but they're also asset protection tools. So again, when it comes to exempt assets, understand what you've got in your state, work with your financial advisor to understand how they might work in your financial plan, because you don't want to use an asset protection tool that has no financial benefit for you. But once you have that, then you want to make sure it fits into your plan and you can leverage it to improve your protection. Unfortunately, we're not going to get all the way there with exempt assets. Even in a state like Florida that has the best exemptions in the country, we're going to need other tools, okay? And these are the legal tools in the middle of that scale that I mentioned that move us from the negative positions to the +5. And the number one set of tools that we use, what I call the building blocks of asset protection, are limited liability companies and limited partnerships. And why do I call these the building blocks? Is because if you own that asset in your name and someone can sue you and take it, that's -5. If you own that, say, investment portfolio inside a properly done and properly maintained, very important, LLC or limited partnership, then someone suing you can't just get to that asset. They have to sit outside, they have certain rights, but they don't have the rights to get in there, they don't have voting rights, they don't have management rights, they may have a right to distributions, but you control the distributions. It puts you in a solid +2 level of protection. You may have to deal with them. You may have to settle with them at some point down the road, okay? That's why it's the middle of the scale, but they don't have access to it. That's why it's not the top of the scale, because you might have to settle with them, but think about that compared to -5, owning the asset in your own name. There's nothing protecting it. They can come get a levy against that account, lien against that account, and take it. So it's not -5 where you have no protection. It's not +5 where you have total protection. It's in the middle where you have strong protections and a good place to negotiate. But what is also important, why they are the building blocks of asset protection, is in the meantime, if you never need that protection, I mean, say I have a portfolio in an LLC, and let's say I'm not sued for 10, 20 years. In the meantime, we can set it up so there's no additional taxes. It's all a flow through, so you're not going to pay any more in taxes, okay? And most importantly, you still have control the entire time because you're typically set up as the manager of the LLC or the general partner of the limited partnership. So you're in control. You decide you want to fire this lawyer, you want to move investments from here to there, you want to take money out, you want to buy another asset. You're in total control, and you have access. So when I ask a client, are you interested in protecting a certain asset if you could have control of it, if you could have access to it? They typically say, yeah, that's of interest to me. And that's why limited partnerships and LLCs are so valuable, because they provide a decent level of protection, and in some states even higher if you have the ability to choose the right state. And it allows you control and access. Now this slide tells you what a charging order means. This is what happens basically if somebody sues you and gets a judgment against you and wants to get to that asset inside of the limited partnership or LLC. They don't get the rights inside, as I mentioned. They don't get a right to the asset. They only get a right to distributions, but you control whether you're making a distribution. So at the end of the day, in the 22 years I've been doing this, the clients who've had these kinds of entities in place are able to negotiate a pennies on the dollar settlement with the person who even has a judgment against them. So even in their worst case sort of nightmare scenario, they're not losing the asset. They're paying pennies on the dollar to get rid of that claim and move on with their lives. And that's why it's a solid level of protection, because of the charging order rules. And again, if you want to learn more about this, we have a whole chapter on one of our books for doctors only on it. Happy for you to even drill down and get even more educated, especially those of you in the audience who are lawyers and want to learn more about this area of law. Now, when you're doing an LLC or a limited partnership, like any tool, you've got to do it right. The medicine has to be done right. And what does that mean? That means really using the right professional to do it. That means the right jurisdiction. That means the right language in the agreement. You can have an operating agreement is different as a will. I could say I'm leaving all my assets to one of my dogs. You could be leaving it to a charity. It's all what's in your will. The same thing. Those protections I just mentioned only occur if you have the right language in the LLC. And I review the work of about 30 or 40 law firms every year because I have new physician clients coming to me with their own documents already, their own LLCs or limited partnerships in place, and most of them don't have all the good language in them. So even if you have these in place and you haven't had them reviewed, I encourage you to do so, because just by having that entity there, if it's not properly maintained, if it doesn't have the right agreement, if it's not in the ideal jurisdiction, if there isn't annual compliance like annual meetings, then it may not be even giving you the protection you want. So these tools are great. If you have them already, you should get them reviewed. And if you don't have them as part of your plan, this is something to seriously consider. Now, you can use trust to protect assets, but the only types of trusts that protect assets are irrevocable trusts. So many of us, including me, have a revocable trust, a trust I can revoke, I can tear up. That's very good for estate planning purposes. But today we're not talking about estate planning, we're talking about asset protection. And the only trusts that provide asset protection are the ones that are irrevocable. You can't change, you can't tear up, okay? That's a big consequence. So again, when I'm comparing for clients a trust where you have to give the asset into the trust and then basically draft it properly, but give it away to that trust forever versus a limited partnership or LLC where you maintain control and ownership, most clients, at least the younger ones, go for the limited partnerships and LLCs. Now, you can see here on the slide, I make notice of a DAPT. That's a Domestic Asset Protection Trust. In about 10, maybe 12 states, it's constantly changing because new states are coming on board. You can use an irrevocable trust to protect against your creditors, but also be a beneficiary of that trust, meaning someone who can get the asset. That wasn't around for the first 200 years or more of our existence in the U.S. About 1999, 2000, the first state allowed that, and now about 10 to 12 states have that. So if you're in one of those states that has that law, you could kind of have your cake and eat it too and create an irrevocable trust that protects against your creditors, but also be one of the beneficiaries that can get to the asset if and when you need it. So that type of trust is something that many clients are interested in the circumstance if they're in one of those states. And again, be happy to contact me and I'll answer if your state is one of those that has that. When we talk about protecting the home, typically it's homestead. Homestead is the way that most clients are going to protect that home. If they don't have a good homestead, we have to get more creative, use maybe a debt shield, meaning borrow money against that home, and put that in a trust like that domestic trust or a limited partnership or LLC. Okay? So again, home is very state specific. It depends on what your homestead is. It depends on what your other options are. Second home, we have more flexibility on because you can put your second home in an LLC. Well, you don't really want to do that on your primary home because there's tax benefits, at least there have been over the years, for the primary home. Okay? So primary home, you might have different options with homestead and other debt shield tools. Second home and other real estate properties, really an LLC is ideal. So as we wrap up, today we've covered one particular topic in risk management and one particular topic in asset protection, which is protecting your cash flow. Two topics, cash flow and your personal assets. But at OJM, we work with clients in a lot of different areas. This chart gives you an idea of the different areas we work with clients on. I encourage you to contact us and learn more about that. We are a multidisciplinary wealth management firm. Asset protection is my area of specialty, but we work with clients in a whole host of areas at the practice level, for employed physicians, individual planning, wealth planning, etc. Our goal when we work with clients is to make their financial life easier, to coordinate it in one place. I have so many physicians who've come to us who have insurance with one person, who talk to one person about asset protection, who have their CPA with their taxes, their investment person is somebody else, but they don't have a good handle on it, it's not being coordinated, it's not under one roof. We have the ability to do that, to coordinate, to be the quarterback. And I encourage you to get more information about what we do, to go to our website, ojmgroup.com, and learn more about us. But at the beginning of today, I gave you the slide that had our books. And our books are the next level of education for you. Here on this slide, you can see the way to get those books. You use the AEI code, you get them all for free, whether they're the new wealth management investment book, whether it's our CME piece, whether it's our flagship for doctors only book. Education is the key to putting these tools in place. I thank you for spending an hour with me and learning about these topics today. I encourage you to contact me with any questions and to get some of our books for free through the AEI system. Thank you.